Hi, this is trial attorney Neil Redmond coming at you from the streets of New York City, and I want to explain to you the concept of something called notice. And notice is a prerequisite, in other words, a requirement for us to prove that a condition existed before the accident happened and that the party responsible for that condition had an awareness of that condition. And how does this play out? Well, with the city of New York, they have to have notice, actual notice, or prior written notice of the condition that a person tripped on, such as a pothole or some type of misleveling of the city sidewalks, or what else? Any kind of a defective condition that the city or one of their subsidiaries is in charge of. They have to know that that existed. And prior written notice is a very technical and tricky thing that has to exist for us to have a case against the city of New York. And what it means is that the city needs to have been informed in writing, prior written notice of the condition that existed that we are complaining about and that our client was caused to trip over or slip over and fall. In other words, to prove that case, we have to demonstrate that the city had that prior written notice. And technically, that cannot include 311 calls. It has to be a written notification that was taken down by a city employee. And that is sometimes a very difficult thing to obtain and to achieve in our system. And so that's one form of notice. Another form of notice that's a little bit different has to do with notice to a building owner or a landowner or any kind of property owner. They have to have a different kind of notice that's either actual notice or constructive notice. And actual notice means that the party actually knew about that condition. And that means that someone in their company admitted, yes, I saw that defect on the floor. I saw that chipped tile. I was aware that the stairs were defective, that they had a hole in them, that they were loose. That is actual notice. Now, something else that we can sometimes prove is something called constructive notice. Constructive notice means that the property owner or their representative, it could be like a building superintendent or some type of a managing agent, should have known about that condition. So what does that mean? That means that the condition existed for such a period of time that the owner or the property manager or the agent knew about it, or rather should have known about it. Now, a good example of this is when somebody drops a item in a grocery store. For example, say somebody spills a glass bottle of oil in a grocery store. Now, there's always a question about how much time went by between the time the glass bottle shattered and the oil was all over the floor and the person got hurt. Setting aside the issue of whether the person should have been paying closer attention or they should have seen the condition, what we're talking about now is the prerequisite to even bringing a case, and that has to do with how long the condition was like that. In other words, if, for example, that bottle of oil broke and was on the ground or the floor of the grocery store, and less than 30 seconds later somebody slipped on it, well, that might not be enough time for somebody from the grocery store to have recognized the condition and cleaned it up. Then another argument to that would be, well, if the glass broke on the tile floor at the grocery store, then somebody at the grocery store should have heard that and responded immediately by running or rushing over to the location and putting down some caution signs, making sure no one walked around the area, Obviously, you don't want someone to get cut by glass, and then you don't want anybody to, slip and fall. So that's going to be the arguments on both sides when you have a situation like that in a grocery store. I'm watching a trial right now, which is a pretty unusual situation, where a lady went to open up the door in a large glass door in a big office building in the city, and another guy came behind her and put his hand on the glass, causing it to completely shatter in an instant. And the building owner, the superintendent, is saying this was a spontaneous act. We had no awareness that this would have or could have happened, and it's not our fault. And the plaintiff's attorney is saying, well, we have an expert that came in and testified that this type of a door does not spontaneously shatter like that without there being a crack or some type of a defect in the door, in the glass itself, that would cause such an event to happen with a very minimal amount of pressure on the glass. And so what happens in that situation is that, based on the fact that the lawyer has an expert, the plaintiff's lawyer has an expert saying that that sort of situation does not happen without a crack, then that shifts the burden back to the owner for them to say, we should have, or the lawyer for the plaintiff to say, you should have inspected this and been looking for cracks in the glass, because, by the way, you've had this happen 2 earlier times, once 10 years ago and once 7 or 6 months before the accident. So that was putting you on notice of the possibility of this condition. And you have people that go around and clean the glass. While they're cleaning the glass, they should be inspecting for these cracks. And the fact that our expert says this type of an incident doesn't happen without the crack being there, that means the crack had to exist, and therefore your failure to observe the crack, either through your cleaners or through inspections that should be regularly done in this situation, amounts to constructive notice. Constructive notice means that you should have known the condition was there. So that's a pretty complicated sort of constructive notice, but a similar situation plays its part whenever there's a defect in an apartment building, in a store, in a commercial space, such as a hole in the sidewalk, a piece of metal sticking up, any kind of defect with the stairway. Oftentimes stairways can have a defect, like the treads could be loose. Or another example is that there could be a missing handrail on the stairway that's required to be there. And when you have situations like that, we oftentimes hire an engineer to come in and measure the condition of the stair tread. Sometimes the height of the stair itself is called the riser, and the riser has to be a certain height in relationship to the step itself, and there are statutory laws or guidelines that specify exactly what the relationship needs to be between the height and the width and the length of the step. And those guidelines are in place to make it so that when a person's walking up and down the stairs, they're able to do so in a normal manner. And one step can't be wider or longer than the other, and it can't be higher, because that would cause a problem with the way people walk, and that in and of itself would be a defective condition. So those are certain types of things that we have to prove as a prerequisite. Now, the other aspect to this is, if we can't prove the notice, the notification, the awareness of the condition, we can try to prove that the condition was caused or created by the actual defendant. In other words, they left a particular condition present when they were done fixing it, or they didn't fix it properly, or by doing some other work, they created that condition. We have a ceiling collapse case where We don't have notice of the loose ceiling, but we do have what's called the cause